Contracts are the backbone of business and personal agreements. But what happens when one party fails to hold up their end of the bargain? This is where breach of contract comes into play, a critical concept in contract law that can have significant legal and financial consequences. Breach of contract occurs when one party fails to fulfill their obligations as outlined in a legally binding agreement. There are four main types of breaches, each varying in severity. A minor or partial breach involves violating some terms of the agreement but doesn't excuse the other party from their obligations. An anticipatory breach is when one party suspects the other will soon violate the contract. A material breach is a serious violation that may relieve the aggrieved party from fulfilling their part. Finally, a fundamental breach is the most severe, often resulting in significant damages. For a court to hear a breach of contract case, certain conditions must be met. First, the contract must be valid and legally enforceable. Second, the aggrieved party must have fulfilled their part of the agreement. Third, there must be the evidence that the contract was actually breached. Lastly, the offending party must have been informed of the breach, preferably in writing. When a breach is proven, courts have several remedies at their disposal. They may award compensatory damages to cover direct financial losses or consequential damages for indirect losses. In some cases, liquidated damages, which are predetermined amounts specified in the contract, may be awarded. Courts can also order specific performance, requiring the breaching party to fulfill their obligations or rescind the contract, relieving both parties of their duties. Defendants in breach of contract lawsuits have several potential defenses. They may argue that the contract was signed under coercion or deception, rendering it unenforceable. They could also claim that a mistake was made during the signing process, potentially voiding the contract. Alternative dispute resolution methods offer faster and less costly solutions to contract disputes. Mediation involves a neutral third party facilitating discussions between the parties to reach a voluntary settlement. Arbitration, on the other hand, involves an arbitrator reviewing the case and making a binding decision. It's important to note that statutes of limitations apply to breach of contract cases. The time frame for filing a lawsuit varies by state and whether the contract is written or oral, typically ranging from 2 to 6 years. In conclusion, understanding breach of contract is crucial for anyone entering into agreements. It encompasses various types of violations, from minor to fundamental breaches. Courts have specific requirements for hearing these cases and offer a range of remedies. Whether through litigation or alternative dispute resolution, resolving contract disputes requires careful consideration of the contract's language, the nature of the breach, and applicable laws.